to order at 6:08 p.m. Stand for the pledge. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Oh, okay. Is there any public comment? Do we receive any public comment? No one here from the public for public comment, okay. Item number 4, old business. A is the Open Space Public Act 490. As you can see, it's a pretty big description. Basically, what this was to do is the intent for open space, wetland, green space, farmland, different levels, the property tax. Basically was put in for developers. When developers would put in homes, they would have to leave a certain amount of space there for them. And they would be able to consider that a low tax rate. But then once they would go and sell it, then an 8%, 8 to 10% conveyance tax would be put on it. But it also allows us to use,
But you're still selling it as open space farming. You're not changing the zone.
well, no, you're not, you're not.
But so they're paying a conveyance fee for the transfer of the open space parcel that they purchased if they purchased bulk. So if they put homes on a section and then the open space parcel that's registered as farmland or whatever, if they sell off the farmland, they're paying a conveyance fee on that?
Yep. So say you bought 30 acres. A
Right.
developer bought 30 acres. And out of that 30 acres, he put 15 homes on an acre of land each.
Right.
So now you have 15 acres. And that 15 acres can either be viewed as farmland or
The-
open space,
The other 50, not
Yep.
the ones with homes.
not the
correct,
ones with the
others.
homes, the other
Right.
ones. And then say he says, okay, well, I made my money, I'm gonna go. Right. So he sells it, he has to pay that conveyance fee.
Okay.
Okay? Now he pays that conveyance fee. Now whomever is taking this land out, I think it's the tax assessor can now go in and say, well, it's 15 acres. It's either are you going to leave it as open space? And if you're leaving it as open space,
But it'd have to be rezoned if you wanted to put homes on
yeah.
it. I'm just trying to understand what the purpose of paying the conveyance fee is. Like, what's the principle? What are you trying to deter, or what are you trying?
Well,
to
it's not ours. It's
No,
the way the
that's what I'm-
regulation is.
That's what I'm trying to understand.
So I think it's for those that, say it's only like, I think it's for as many years as you have it. So say you have it for 5 years, you pay a certain amount.
Okay,
But
so
say
it's
you
a
have it for
sliding-
15,
Got it, okay.
you pay a less amount,
I get it.
you know?
Yep. Okay, that makes sense to me now. So it'd be some sliding scale.
Mhm.
Okay.
But I think it would be good for those pieces of property in town that truly are not farmland by descriptions where they sell their wares. We do have we have horse farms that have acreage, that have woods on them, that this may be able to fall under. Not farmland for the say of we're raising cows and selling the beef or selling the milk. Not a true farm because it's not selling the wares, but it's still a farmland because of what it's doing, the description of it.
Okay.
So now I guess we have to take this and say, do we want
Would
to?
this deal with one of our residents' issues that we've had?
Yes.
Okay.
But this public act is state law. What are you proposing that we do?
We can take it in turn as, go ahead, Rory.
Rory's right.
Rory Burke.
It is an opt-in. So the state provides the option. The town has not adopted this as an option for people to apply. So we have the farm exemption, but this one is not an option for our residents.
And we do have a resident that's actually
Because we've had
good.
particularly this past year with reval,
Mm-hmm.
a lot of our farmland are appealing
Right.
their appeals. and, you know, a lot of
So
them.
if we adopt this, then,
In some form, that we're gonna have to work on the drafting of it. It's not just
Right.
opt-in.
it's not all or nothing.
Yeah.
Right.
But it's an option for people who wanna preserve their land without development, but who maybe don't meet the statutory
Right, I get it.
assessor's interpretation of the law.
Got it.
And really, I have to, no offense, Roy, I have to thank Stephen for doing this. Stephen has done a lot of legwork on this Public Act 490 and putting together the primer for it so that we have it.
Can I add 2 cents?
Can't
It
you-
makes so
Yep.
You have to go to the microphone, state your name, please, and your position.
Stephen Perry, assistant to the first selectman. This is kind of the opposite end of what the tax incentive subcommittee is considering.
Mhm.
So Fred and the tax incentive subcommittee is considering, you know, abatements or basically discounts, honestly, to attract businesses to Seymour. This is naturally the opposite end of that. It's providing an incentive, a tax break for developers to preserve open space. So it's a little bit of a seesaw with, you know, Seymour doesn't have much of either kind of property. But it's still something to consider both ways. Are you going to slightly prioritize open space? Are you going to slightly prioritize redevelopment? Because it's exceedingly difficult to transition redevelopment land into any kind of agricultural use.
We do have the balance because we do have enough
Yeah, so that-
properties out there.
Oh, yes, we do.
Yeah, so that's just something to keep in mind.
Okay. An effort to get this done, what's the, we nod, we say, okay, what's the
We
next step?
move this forward to, I believe we had to move this forward to the Board of Selectmen.
You guys are on board in theory with, then it's about, we can do some research and come up with some recommendations for the standards. Is it parcels have to be larger than an acre? Is it that?
Okay, so we can give it
2
size, we
acres?
could write.
I forget the exact, but there's a series of criteria you guys need to establish if you're gonna adopt this. So it would be about developing.
And who would work on that? That's the, so,
Can we have the land use board work, the land use department work on this, or the board work on that?
We could, the planners would be an excellent resource.
Yep.
I'm sure they're familiar with this. And probably in conjunction with our office, the planners and the assessors, we could come up with a set of recommendations, which then you guys could put together.
The easiest kind of understanding of this would be when someone is trying to claim farmland, you know, the most common way to measure that is what percentage of the total acreage is used to farm, produce an agricultural good and sell it. You know, that's kind of the easiest way to think about it, and I have some metrics on like what most towns consider, so that's available to you.
okay.
For example, some communities will do, if you have a single family home on a parcel. If you have a single family home that is on, let's say, 10 acres, you could claim, 9 of those acres as open space anyways. And the gist would be, you're preserving for the town at least 9 acres of open space for a period, I believe, of 10 years more. Right, otherwise there's penalties that they have
Right.
to pay for not doing, if they make the application. You could say it has to be completely vacant land, with a size of greater than 2 acres. So that you guys will set the criteria, because obviously a single family home on it, that opens it up to a lot of people. If it has to be completely vacant land, it's a little more specific. If it has to be of a certain size, a lot of the zones around in Seymour are an acre or smaller, so that's how you wiggle this around to kind of target what land you want to preserve for open space. And that's where the planners will come in, taking a look at the zones, taking a look at the parcels that are out there, and figuring out what it is you're trying to preserve.
So what is the committee's pleasure? Is the committee pleasure to move this?
I'm just a little confused.
That's
There's
fine.
already a statutory scheme in place.
There is.
Statewide.
But you don't have to opt into it. As a community, municipality, you don't have to opt into it, even though there's a state law in place. That's up to the assessors and up to town ordinances if they want to opt into it.
Okay, all right.
Yeah, so if we haven't opted into it, I'm on board to opt into something like this.
Steven, you
Especially
checked
for,
with Joe on this? Sorry, Rory.
But we have properties that are classified as forest land, I know that.
Through the assessor, go ahead.
So this came about, we just had a reval year,
Yes,
and like I said, a lot of the farmers, what the statute says for the farm exemption, it does not give like a hard, you must farm 1 acre of land, you must
Right.
clear this amount of money, so a lot of it is left up to the discretion of the assessor.
Correct.
And our assessor, took kind of a hard line, and as a result, we got a lot of,
Angry residents.
farmers, you know, people claiming farm status who came to the the Board of Assessment Appeals. And then even after that, they didn't like the outcome and they were suing the town about their assessment. So, the assessor's office brought this to us as a way, if you don't meet, you know, the assessor's idea of what a farm is, as long as you meet
okay,
the standards set by
okay,
this board
Good,
for what
okay.
qualifies as open space.
okay.
this will
Yes.
override it.
Well, it just gives them it's
better
still up
understanding.
to the
Right.
assessor's discretion per statute. It's just another avenue for people to pursue when, you know, if they're honestly just trying to keep, you know, an old family parcel together, and they don't wanna sell it to a developer for, you know, a development. They just wanna hold it and keep the character of it intact. This offers that option if it meets the criteria set by.
Right.
So an application would be filed here?
No, because it has to be set by ordinance, this board sets the ordinance, but then, same way the farm status goes, it goes through the assessor's office when they're making their,
But we'll have the ordinance that's on the books. That's basically,
correct. Like I said, it's just another avenue, for them to pursue.
Okay, well, I didn't read the entire act, I didn't have time, but, okay, all right, I got what you're saying.
That's my understanding of it from that, you know, information packet there.
Fred, do you want to take more time and read
No,
the
that's fine.
You know, if you guys, if the pleasure of the board is to move forward to start creating those criteria, I mean, this is far from over anyway.
Mhm.
So you know, you'll have more time if you want to familiarize yourself with it, and, if at that point it's the pleasure to not adopt it, that's.
this is just giving us the first step,
Yep.
basically.
Correct, that's some background information, the general gist of it. There's some about that covers the farm, exemption as well. There's a lot of information in that packet, but.
Thank you. What is the committee's pleasure? To move forward, to inquire, to start putting it together?
I'm looking to move forward too.
I think that someone, whether it's your staff or town attorney's office, draft a sample, a draft proposal for us,
Yeah.
a draft ordinance for us.
Okay. Have a motion?
So moved. Motion.
Motion to move this
Move forward.
forward.
Second motion.
Motion by Bob, second by Fred. Sorry, I just had a brain freeze on
Easy to
there.
forget.
Okay. We have a open thing at 6:45. The next one is, section 10 through 15 massage parlors. So you remember the massage parlors? This was, we had a massage parlor come in, and we have a different ordinance for massage parlors, and we have a different ordinance for, adult services. I think if we took out the adult services, I think we had to wait to the new fiscal year to run that for public comment because it was so long in length. And if we go in massage parlors, we just take it and we put it into the adult services and we look at it, we can say, well, if you're putting in because massage parlors are really now nails, you know, the nail salons, because they do massages on your hand. You get a foot massage, a pedicure, they're doing a foot massage. We have a massage parlor that couldn't open for 3 months because they had to go through the police department to get a license. So I guess what we have to look at is, do we just want to take the massage parlors and put it into the adult services and do away with that standard?
You mean mix it together?
Mix it together.
My opinion is we leave it alone.
Okay.
I don't see massage parlors, there's been abuse, and that's what was concerning here in Seymour when this ordinance was passed, that there was abuse, possible abuse. But massage parlors are not supposed to be adult-oriented.
They're not
entertainment.
supposed,
They're
okay.
not supposed to be.
So we're going to leave massage parlors
Well,
alone?
that's just my opinion,
No, that's.
you know. It's-
Well,
Fine.
if we mix it together, it's gonna be difficult for a massage parlor if they wanted to, if they're
open.
legit to be,
Right,
so it'll make it harder for them, right? So I think you have to
Yeah.
clarify, if you have a legit massage business, it should
Right.
have its own,
Okay.
that's a good way,
right?
that's a
Yeah.
good
I
way
agree.
of phrasing it, yeah.
That's a good way. So let's leave it alone. So we're gonna leave massage parlors alone. Stephen, why are you looking at me like that?
No, I'm sorry,
Okay.
it's just my neutral phrase.
Okay. And then, all right, so we agree we'll leave massage parlors alone. We won't touch that one.
No, can I ask,
Sure.
Selectman, what was so it was just that we were reviewing that particular piece of ordinance, or did something,
Oh, so
Stand
what,
out.
yep, so what happened was we have a business in town that opened up. And because, massage parlors now have to have a police officer, you know, we had to have the chief sign off on things. They lost 3 months.
right?
So I think it was just to better streamline it.
Is there anything we need to do here to make it cleaner so that doesn't happen again? That's my other question, because what, if we keep it separate, because it was separate and it still caused the problem.
It is, I think we just need to look at it and go through it and make sure that it's very clear. Maybe we don't have to have the police sign off on a massage parlor. Hello, Rich.
Because by definition, they're not supposed to have any adult themes in the
Correct.
massage parlor. So, that's what I'm trying to weigh. Does it make sense for them to still have to?
See, and in E, you need approval by the police chief. Upon receiving the application for a massage business or masseuse permit, the police chief shall conduct an investigation into the applicant moral character and personal criminal history. The police chief may at his discretion require a personal interview of the applicant and such furthermore information, identify a physical examination of the person, and shall bear on the investigation.
So who checks the employee ages things? Can I, again, an ordinance, it's gonna say the employees have to be 18 years. Who validates that?
That's on the police, it all
So
has
that's
on
why
the
the
police
police has
chief.
to be involved, right?
So it's
'Cause
on the
there's no other
police chief.
process to
But
be
say
able to do
you
that.
wanted to have a Viso Bella spa come in here,
Mhm.
right? Like they are in Quarry Walk,
Sonabella comes in here,
Sonabella, right?
sure.
They offer massage. So now the chief has to go through, has to interview every single person to make sure that they
Yeah,
have.
because that's on this item in the massage parlor.
Yep.
Yeah.
The administrative burden is large.
On the police, on the chief of police.
Is there a different, I'm throwing this out there, is there a different way to do that, or is that the only way?
The ordinance says what has to be done and who has to do it. You could assign it to somebody else, you could take away some of the requirements.
Now, the police would be the right place because of the records, right? I'm
Mm.
guessing, because they could look up personal records a lot easier than,
Mm-hmm.
They can perform that for anything.
right?
Maybe we just go through it. Maybe we sit there and say, maybe it's not the police, maybe the
Well-
police chief, maybe we just say, the police department, so he can assign it
Well,
to a detective.
well, that's
or an
what I was going with, and, you know, is there in any of these ordinances, can we put a turnaround time? Can we put a service level agreement where we're saying, you know, this action, let's say it's a 2-week process or a 1-month process, that it's a part of the ordinance? Because I think, that's a problem too, because if I was coming to do a business in town, I would wanna know how quick I can get this turned around, right?
So this issue came up, there's a business on Main Street that
Mhm.
came in that is predominantly in the south. And so somehow it came to people's attention that this ordinance existed. I think it had kind of fallen out of people's memories that this was a thing. And it said, there shall be a form that shall be created by, you know, the chief of police. There was no form.
There was no
So
form.
now he has to go figure it out, come up with
He's
it.
working with the town attorneys,
That's
they're
a big miss.
scrambling to, yeah, it was embarrassing.
But the ordinance should already identify the form that's required,
It
seems to
it
me.
should have been created, and maybe it was.
Yeah.
But I think, you know, apocryphally, this had to do with a business that was here in, you know, the 70s. And so maybe it was created and maybe it had never been used, and so it kind of disappeared, you know? But then the question came up, you know, salon-type businesses where they also do massages. They haven't done this. And so that the police department's gonna have to go around to every single nail salon that does, you know, foot massages.
Right.
Maybe, you know, so it just, we were asked to take another look at it.
I think there's some changes we have to do in here, because it shouldn't be the police chief, it should be by
Or
department.
his designee, you know,
There
whatever.
should be a form that's associated to this that it should already identified. There should be some type of service level agreement that says it's gonna take you 2 weeks or a month, whatever, to get this transacted, whatever, you know, I don't know.
Well,
Because we-
if
go
I
ahead.
may ask, Rich, counsel, the terminology, the police chief, that means the chief has the authority to delegate to his staff to do the investigation, but the police chief has to sign off at the end. So,
Is that clear to them, though? Because it does say
It was not
approval by
clear to them.
police chief, it's very definitive. Yeah.
I mean, in most departments, a police chief, will, have sergeants and lieutenants and captains and.
But why wouldn't this define police department? Why is it define the chief?
Because they want the chief to be the ultimate signer of the authority. And when the permit is issued, now it's like a gun permit. When who issues a gun permit? The chief. Under
I-
state laws, the
Okay.
chief. And the chief is the top law enforcement, not the board of police commissioners, not the chairman. The top law enforcement official for the town of Seymour is the police chief.
Mhm.
How's that?
Okay.
Pretty good.
Yeah. And post, the academy, they don't want many things have to have the chief's signature on it. Not the first select woman, not the chairman of the board of police commissioners, they want the chief.
So before anybody can look at it, before it can go to public health, before the board, you know, it has to go through the police chief for first sign of his approval of this application. And I think that's what held it up, is that the chief never signed off on it, so it couldn't go to public health, so
There was no form.
there was no form.
That was the big, so now that should be remedied. But it brought this to light and they have to take it separately.
Okay.
I'm willing to buy that, but I think we should actually, there should be, if there's gonna be a form on something like this, it should be.
It should be
done
called
and
out in the ordinance as
accessible
to
and
what form.
Somewhere where people can get access to it.
well, if I were a business owner, trying to open up this business and told it wasn't a form, I'd be jumping up and down with my counsel saying, at least produce a letter, chief of police.
Right.
You've gone through this process.
So let's take this and look at it, find that form, put that form name into the ordinance.
Would
Okay.
you like us to take a look at this?
What do you think? I don't think it would hurt.
I think there's some improvements here can be made.
We'll compare and contrast with some other ones.
But, I know we're picking on this particular one, but I'm sure there's others that have a
Very near
similar,
and dear to our
well, it's more
heart.
structural to me.
This
You
one is
know?
Karen's. This is very near and dear.
I
This
knew you were
is
gonna
Karen's
toss up.
ordinance.
Part of like the form issue.
Karen's
is that
ordinance.
when
What's the type?
ordinance is
Miss
written,
Hodgkin.
everything's analog.
There,
and then
there,
you
would-
just
there,
digital. If it's not
the one
a
modeled
catalog
after
form
Milton.
that
Yep.
you-
Yes.
when staff
This-
comes over,
Yeah,
this-
like,
I'm sure
to
that
Fred's
it
point,
was not used for so long that it was just small.
rest assured, please decide somebody.
But this had a template that identified the actual thing and it had any forms that would be a part of the template, it's always there. Date it was done, that type, just the repeatability stuff or something like this, I don't know.
I think what we did is they just took, I could be wrong.
You don't want to, may I make a suggestion about, I hear this about, he is concerned about services, concerned about general. One, Selectman Stanek in his role as an attorney is aware of this, there's certain things. And there are certain places in the law where an application is taken and it's held for so long, and at a certain point it may be being granted if no action is taken. You don't want to create that sort of thing there. And the second thing is, I don't think you want to write a form into your ordinance in case you want to modify the form. In case something comes along by experience and says modify it, or you want to do something different, the chief or whoever he's assigning this task to suddenly says, no, we never thought of this, this is how they're doing it down in Milford.
Yeah, but you can point to a location that has all your current updated records. You could put that in here, location X, or wherever that,
What you would do is, you would have like, on the zoning walkthrough, in many towns, and I don't know if that's familiar. If your client comes in and is making an application, before the sign off in zoning, they might have to go to building, fire department, wetlands, they have to literally go around and get all their sign offs, and then boom, it'll go to the zoning administrator in a particular town, before something's signed off on it, before it's really ready to go forward. Things like that can be done.
Okay.
And created. But
Yeah.
I wouldn't put the actual form in the ordinance. I might put things that you minimally expect to be on the application, but it would be an including but not limited to type language, in case somebody wants to alter it in the future.
yeah, I'm making recommendations that might not be correct. There's probably better ways to do it. I'm looking
No.
for a repeatability thing. How do
Yeah.
you make it repeatable so you don't have to think about it? This is part of the process.
Every time.
Right.
well, the police chief is supposed to furnish the form. Perhaps we could have counsel's office prepare a form.
Yeah.
Perhaps you have an intern or
Yeah.
law student who could
Yeah,
do that.
And what we would probably do is, line some of our
That's it,
places.
yeah.
And see what
Obviously, the police chief, whoever he has been, hasn't produced the form over the years.
you probably
So-
don't have any applications.
Right.
Right.
There are
Right,
other-
so we never,
There are other
yeah.
communities that had to deal with, multiple applications. So it's more common.
I don't,
But all kidding aside, she made the point, even nail salons, if they start to do, they need a process, right? They would have to
Yeah.
go do the same thing, right? Okay.
I mean, this is something the police chief, whoever he or she might be, doesn't, puts aside. So I suggest that we create a form through the council's office, look at it, and say, police chief, this is your form.
Okay, motion made by Fred Stanek,
Second.
second by
Okay.
Bob. All in favor?
Aye.
Aye. Chair votes aye, motion carries 3-0. Motion is to send this over to council to have council come up with a form.
You,
Okay,
you give me some agita
I do?
about the motion. I just was commenting. You made it into a motion.
Did. Like that, huh? Chapter 2, Article 3. I don't think, that was really nothing. I don't think we really got to look at that one yet. So I like to table that one or move it to our next meeting.
What, Article 3.
Yep.
do Article 3, okay.
Yeah, there was really not a lot of stuff in there, but let's just, because remember oh, Fred, you kind of
I
need to.
think I remember you saying,
Sort-
yep, I do remember.
We wanted to take the ordinance and go section by section to make sure it's up to
Okay.
date, so that was the next one.
Okay.
Okay. And the next one is the gender neutral board of select person. In your packet is the one that Selectman Stanek sent up his red copy.
The very last page.
I had drafted a proposal, and then the first select woman wanted to be able to retain the use of the term first select woman or select man as appropriate, so I modified it further.
I was channeling Karen on that one.
I'm sure you were.
I was.
You didn't like the term first select person.
I did not, because
That's fine.
But I think it's fair to call them all out, because it's still identifiable to a gender, so it's not.
Absolutely.
It's whatever they feel comfortable with,
Exactly.
right?
I agree. When I first prepared the first draft that I submitted, I just dictated it off. I didn't even really, and I read it once and I submitted it. I said, well, this is good enough for a proposed document for comment, so your comment is well taken.
So, if you look at it with the changes, proposed gender neutral ordinance regarding the Board of Selectmen and the office of the first select woman and first select man. The changes are the first select man and or select men are hereby amended to substitute the term or phrase select man, first select woman, and or select persons. All references in the ordinance, regulations, codes, executive orders, policy, or other documents to the term his shall be substitute with the phrase his or her. To the extent that the use of the term first select woman and select persons is inconsistent with the use of the terms first select man or first select men in use in the town of Seymour charter or general status, regulations, policy, executive orders, directives, documents passed, approved, or otherwise utilized by the state of Connecticut or any government department or agency. Therefore, the term first select woman and select persons shall have the same meaning as first select man and select men as otherwise used in the town of Seymour charter or used by the state of Connecticut in such documents. My only question on this, Rich, is any contracts we have currently, would this void them by making this change?
No, I mean, you can add it to
Okay.
it on all, or after, you can add it after.
Okay. Do I have a motion to accept this ordinance?
Motion to accept.
Motion by Bob Finley,
I'll second, then I'd like to comment further.
absolutely. Second by Attorney Stanek. Discussion?
Obviously, this does not apply to the charter, because the charter change would have to be through the charter process. So
Correct.
the next time we do charter revision.
Right.
But I think this is a start to bring us into 2022. I'm
Absolutely.
just surprised that the legislature hasn't taken some action. But I was talking to someone, a staffer at the legislature, yesterday, and he said that there was some consideration on a task force that was supposed to be appointed some years ago, but it never got underway. So I don't know what the holdback is. And it's interesting, I did a little bit of research. The term select man, select men, came to be back in the 1600s after the colonists first arrived in the country. And in the New England towns, small towns, people took on roles of what responsibilities that they had in small town government. And as the populations increased, the people that had from the town meeting, the legislative body, elected select men, select-men, because women were not voters. They elected the voters. And that's how the select men term came to be. It's never been changed.
Well, now we're changing.
So I just thought it was a good idea to try to talk about it.
So if we want to clean this up so that we can propose it to our next Board of Selectmen meeting, March 1st,
Yeah, so just accept the red lines and.
accept the red lines and move it forward to the March 1st meeting? All in favor?
Aye.
Chair votes
Does
aye.
council have any comment?
I just want us to add
So moving like a moving forward,
Yeah,
Yep.
anything after a certain date.
probably best, right?
Yeah. Okay. That's good. All right.
Okay,
All right, so that's that. I can have a motion to adjourn.
Most your turn?
Motion by Bob Finley,
second.
second by Fred Stanek. Chair, all in favor?
Aye.
Aye, chair votes aye, motion carries 3-0. At our next meeting, we need to pick chairs. We need to pick a chair and a vice chair, remember, because in January meeting, it
Oh,
was
yes.
just you and I.
Yes.